It's 12, so welcome. Thank you all for your attendance today for this IUA market briefing on the EU's Digital Operational Resilience Act, or DORA, as it's better known. My name is Helen DL, and I'm the Director for Public Policy for the IUA. DORA will apply in the EU from the 17th of January 2025. The deadline for compliance is fast approaching, and some of the requirements will take time to meet, including remediating contracts to meet the prescriptive requirements. At this briefing, our guest speakers from DAC Beachcroft will provide attendees with essential knowledge to navigate this new regulation. In addition to operational resilience requirements in the UK, DORA has been a topic of discussion at many of our committee meetings recently, and we hope that you will find this briefing informative and useful. There will be opportunity to ask questions online via the Q&A facility, the button at the bottom of the screen, which the speakers will attempt to answer at the end. So without further ado, I will hand over to Jade Kowalski from DAC Beachcroft for introductions and the briefing. Thank you.
Great, thanks, Helen. Many of you will already know the DAC Beachcroft Data and Privacy team from our work supporting the IUA DPC committee. We really value that relationship, and we're delighted to have been asked to update IUA members on the topic of operational resilience. So today I'm pleased to introduce you to some members of our broader team, Mathew Rutter, who specialises in insurance regulatory work, and Tim Ryan and Alistair Cooper, who specialise in IT and tech. But first, I'm going to hand you over to Peter Given, the newest addition to our data and privacy team.
Thank you, Jade. Thank you. Could I have the next slide, please? That's who we are, just in case you can't see us. Next slide, please. So what are we going to be covering today? Well, I'm going to kick things off with an overview of DORA and what it is and some of its key requirements. And then I'm going to hand over to Mathew, who's going to look at operational resilience in the UK and how it compares with the regime under DORA. And then Tim and Alistair will be looking at contracting and how DORA applies to your ICT services contracts. And then I will be finishing up with sort of what's next and what's on the horizon. As we said, there is some time at the end for some questions. So obviously, if you've got any questions as we go through, feel free to add them to the Q&A text, and we'll endeavour to try and get to those. Next slide, please. And the next one. Thank you. So what is DORA? It's obviously something that's very important, very interesting to a lot of attendees, given the large number of people on the call today. So I think it's worth perhaps taking a step back and looking at the context and purpose of DORA. So information communications technologies underpin the financial services industry now, and they bring many efficiencies and benefits to businesses and consumers. But there's obviously a risk inherent in ICT, such a heavy reliance on ICT technologies. And the interconnected nature of information communications technologies means that if something goes wrong, it can have there's the possibility for it to go seriously wrong and have an impact on, in this case, the entire EU financial services sector, or at least that's the risk that the Commission was alive to. So back in 2020, the Commission issued a digital transformation strategy. And part of that strategy, one of the elements, one of the priorities of the strategy was around ensuring that while organisations were taking the benefits of information technology, that there was a framework in place to ensure that that there is sufficient resilience in the sector. And so that strategy, or alongside that strategy, the Commission proposed a framework around digital operational resilience, and that ultimately became the Digital Operational Resilience Act that we will be discussing today. But at a high level, what DORA seeks to do is effectively address ICT risk management across the EU financial services sector and harmonise some of the disparate risk management regulations that existed pre-DORA. As we mentioned, the DORA took effect in January 23, and we're currently through the two-year transition period, which expires on the 17th of January 2025, when DORA will apply. So as I say, we're sort of quite some way through that transition period, and we've got about 7.5 months left before DORA applies. It's also worth noting that alongside DORA, which is an EU regulation, so directly applicable, there is a DORA directive, and that directive amends various financial services directives to bring them into alignment with the requirements of DORA. Please go to the next slide. So who does DORA apply to? Who does it impact? Well, it effectively applies to a very broad range of EU-regulated financial entities, and the scope of DORA is set out in Article 2. It actually covers covers 20 different categories of financial entity, and so it has a very broad application. However, there are certain exclusions to DORA, and in particular, certain low risk or small entities are excluded from its scope. So, for example, insurance intermediaries and reinsurance intermediaries are within the scope of DORA generally, but those that are micro enterprises or small and medium-sized entities will be excluded from the scope of DORA. Interestingly, DORA also applies beyond financial entities to critical ICT third-party service providers. What I'll come on to talk through is the sort of very prescriptive requirements of DORA, and those apply to financial entities specifically. They don't actually apply sorry, I've lost the slide, if it's still there. Oh. I'll just keep talking. If it's possible to have the slide back, if you can still hear me. Yes, so the sort of prescriptive requirements of DORA apply to financial entities, but what DORA does create is a framework, an oversight framework for ICT third-party service providers. So while they're not subject directly to all of those onerous prescriptive requirements that we'll come on to talk about, there is an oversight framework that critical ICT third-party service providers will be caught by. And as a result, they will effectively have to bring their operations into compliance with the sort of the principles and requirements of DORA. Please could we have the next slide? Thank you. So what is digital operational resilience? Well, it's defined in DORA, and it has sort of in typical EU law fashion, a very long-winded, lengthy definition. But effectively, what that definition is saying, what it's saying about operational resilience, is that operational resilience is the ability, or digital operational resilience is the ability of an organization to withstand impacts on its ICT network, on its ICT technologies, and be able to continue the provision of its services. So effectively, operational resilience is taking steps to ensure that you can continue business if your ICT network suffers some sort of impact or incident. Next slide, please. We've set out on this slide just a broad overview of the different chapters or elements of DORA, but it's worth thinking about DORA in terms of, insofar as it relates to financial entities, in terms of 5 key pillars. And those 5 key pillars are the first 4 items on this list and the bottom one. So we've got ICT risk management, incident management, classification and reporting, digital operational resilience testing, management of third-party risk, and then finally information and intelligence sharing. As I mentioned, there is an oversight framework for critical ICT third-party service providers, which is obviously something that applies to those service providers rather than to financial entities themselves. Next slide, please. DORA itself is for those of you that have read it, you'll note that it's a very long prescriptive piece of law, and effectively, I mean, in a way, you could look at it almost like a checklist. It's a very long prescriptive set of requirements that, as I say, are broken down into these different pillars. So in the interest of time, what I thought would be helpful is just to pick out some of the key requirements and themes for under each of these pillars, but just noting that this is an extrapolation of those requirements, and actually, as I say, the devil's in the detail, and there's a lot of information under each of the different pillars. But if we start with the first pillar, which is ICT risk management, what DORA requires is that financial entities must have a governance and control framework in place, and they must also have a comprehensive and well-documented ICT risk management framework. That risk management framework is intended to be a living document, and the DORA requires that to be regularly reviewed, particularly after an incident, for instance, where there would be need to sort of kick the tires on the risk management framework to make sure that that financial entities are learning from real life scenarios. DORA is very prescriptive about all of the different elements of that risk management framework. So it covers things both sort of from a more kind of documentary policies procedures perspective, but also technical requirements around access control, for instance, but also things like business continuity, disaster recovery, and so on, as well as a requirement to effectively map IT assets and undertake risk assessments. So it's a very comprehensive set of requirements around ICT risk management. There's also a particular provision directed at the managing body of the financial entity, and it makes it very clear that that managing body is responsible for, ultimately responsible for the ICT risk and the strategy to addressing it, and that falls on the managing body. And there's also a requirement to effectively ensure, so that that body can discharge those duties. There's an express requirement on them to make sure that their knowledge remains current and up to date, and they have the skills necessary to discharge that function. The next pillar is around the reporting of ICT related incidents. So effectively, an ICT related incident is an unplanned ICT event that has an adverse impact on the data or the services of a financial entity. And what DORA requires is that financial entities have in place systems to detect, monitor and respond to ICT-related incidents. And it also introduces an incident reporting obligation. So in particular, where you have a major ICT-related incident, so one that has a sort of high adverse impact on your critical and important functions, there is a need to notify the relevant competent authority for the financial entity. And if there is a financial consequence for clients as a result, then there is also a need to notify clients of that incident. So very similar to the GDPR regime, if you're aware of that. Obviously, the scope of DORA is beyond personal data processing, but it's the idea of sort of a two-tiered breach notification regime is aligned to some extent with what the GDPR already requires. The third pillar looks at digital operational resilience testing, and it obliges financial entities to have a proportionate and appropriate digital operational resilience testing, and DORA specifies some of the things that could fall within that, what would be deemed appropriate. So things like penetration testing, open source surveys, and so on, and sets quite a sort of a broad range of measures that are required. It does say that, again, sort of tying things back to critical and important functions, that there is a need to carry out testing on all ICT systems that support your critical and important functions at least annually, so every year. And for those organisations that are particularly significant risk to the financial services sector, as designated in DORA, there is a requirement to carry out comprehensive threat-led penetration testing at least every 3 years. And DORA, unsurprisingly, you'll pick the sort of general theme here, is very prescriptive about what that TLPT should look like and how it should be performed. Could we have the next slide, please? Thank you. I won't spend too long on the management of ICT third-party risk because Tim and Alistair are going to look at that in a lot more detail. But suffice to say that DORA does create an ICT risk management, third-party risk management framework, and that has both pre-contractual requirements around things like audits and due diligence on your suppliers, but also contractual requirements, which we will pick up shortly. And then the final pillar that I wanted to touch on is cyber threat information and intelligence sharing. So DORA encourages, but doesn't mandate, so this is a sort of voluntary scheme, the sharing of cyber threat intelligence between financial entities, and it sets out the framework within which that should be carried out. And obviously the purpose there is to enhance the kind of collective ability to achieve operational resilience through the sharing of information about threats that organisations are facing. Before we move on to look at the UK regime, I just wanted also to touch on the fact that DORA has a proportionality principle built into it. And actually, the way I look at this is that effectively proportionality is built in two ways. The first way is this explicit proportionality principle in Article 4, which effectively says that financial entities should adopt a proportionate approach, taking into account the nature of their organisation when they're implementing the requirements of DORA. But there's also an implicit proportionality principle, proportionality element built into DORA, in that various requirements of DORA are lessened for lower risk financial entities. So for instance, there's a lighter touch risk management framework regime for particular types of entity, rather than the sort of comprehensive ICT risk management framework that I discussed a few moments ago. And similarly, what we'll come on to say, for example, in terms of contracting, is that there's sort of a two-tier approach, and the more risky contracts have a sort of a more higher standard, more onerous requirements attached to them, so therefore reflecting this kind of approach to proportionality. Next slide, please. And I'll hand over to Mathew.
Thanks, Pete. Yeah, so we thought it might be helpful to do a bit of a compare and contrast between DORA and the UK's operational resilience regime, because there are some significant differences between the two, but many people in this audience are likely to be certainly within the scope of the UK regime, if they're also, and potentially also in the scope of DORA. And the most obvious difference is that the UK operational resilience regime covers a much broader range of threats than just ICT risks. I mean, the regulators in the UK started talking about operational resilience as a concept in around 2018, but it really took off as a result of things such as the COVID pandemic, which is obviously not an ICT risk, but a potential systemic risk for financial institutions as well as other businesses in the UK, and also some of the firm-specific events that we've seen in recent years, such as some recent bank IT failures. So all of those are sort of captured within the UK regime. And the regulators, both PRA and FCA, have made rules around operational resilience, and we're in the sort of phase where firms should be implementing the necessary measures to manage operational or achieve operational resilience. And there are four key elements that they've identified. So there's preventing disruption as far as that's possible, adapting your systems and processes so that you can continue to provide services and functions in the event of an incident. So that might be alternative backup systems, trying to remove single points of failure. The ability to return to normal running promptly when a disruption is over, and also a process to learn and evolve from incidents and near misses. So all of those are the sort of the four key components, if you like, of effective operational resilience. And as I said, by the 31st of March 2025, the firms that are in scope of the UK operational resilience regime are required to have sound, effective and comprehensive strategies, processes and systems in place that enable them to address risks from their ability to their ability to remain within their impact tolerance. And I'll touch on that in the next slide. And for each important business service, and again, we'll look at that on the next slide, in the event of a severe but plausible disruption. So it's very much about having appropriate strategies in place, but not necessarily being as prescriptive as DORA is about exactly how you achieve that. So if we go on to the next slide, please. So the concept of important business services, and this is something for each firm to identify, but essentially it's about services which a firm provides, which if they're disrupted, could pose a risk to the firm's safety and soundness, or the soundness of the UK financial system more generally. That's the sort of PRA's angle. The FCA's definition is slightly different. They focus on service failure, which could cause intolerable levels of harm to any one or more of the firm's clients. So perhaps not surprisingly, FCA is more focused on client outcomes, PRA is more focused on outcomes to the firm itself. But obviously the two may well be captured within the same risk. And in addition, for insurers specifically, they also need to identify important business services that may pose a risk to policyholder protection. And the PRA's summary is that a firm's important business services, as defined, will be a relatively short list of external-facing services for which the firm has chosen to build high levels of operational resilience in anticipation of operational disruption. So they're not expecting you to list that many services. And of course, the more you list, the more you're going to have to build around those services in terms of your systems and controls. The FCA have given as an example of claims handling as an important business service when carried on by an insurance intermediary as agent for an insurer. So that gives you one example of something which may well be regarded as an important business service for, say, an MGA or broker. Quite helpfully in terms of timing for this talk, the FCA have given some observations on what they've seen in firms who are preparing for that 31st of March deadline. And I'll just sort of touch on a few of these. There's a number of factors. Hopefully you're familiar with at least where the rules are. They're in CISC 15A. And there's a number of factors the FCA have set out in their rules for identifying important business services. But they've found that some firms are, I think, maybe treating the list as you having to show all those factors for a service to be regarded as an important business service. You don't. Any one of those could be a factor that leads you to conclude the service is an important business service. And also, you're just looking at the factor in isolation. The fact that you may have response and recovery capabilities, so you can bring it back up or have a backup alternative, doesn't mean it's not an important business service. That's about how you mitigate the risk, but the risk is still there, and therefore you should categorize the service as an important business service. And the key thing, as in so much of regulation, is that you're then required to do a self-assessment of why something is an important business service, your rationale for including it. And I think those will be the things that regulators will look at, how well you've documented your justification for categorizing a service either as an important business service or as not being within the definition of important business services. And particularly if you say, because you're required to do an annual review of your categorization, if you choose to remove a business service, either PRA or FCA might well ask you to explain in some detail why you've reached that conclusion. So you need to be documenting that thought process. The other key concept is impact tolerances. So in other words, that's not to say that you need to get to a position where there is no adverse impact as a result of a failure or disruption. But what this requires you to do is to work out what you think as a firm is the maximum level of disruption that can be endured while still be able to provide the service. So some degree of impairment or degradation may still be acceptable and tolerable. But you as a firm have to think about where that point sits. And again, that's something you need to be able to set out and explain and give a full rationale of how you've accept a particular impact tolerance. And that needs to be understood by the firm, in particular by the board, and also by the regulators. They need to be able to come in and understand how you've decided on a particular level of impairment as being acceptable. And again, the FCA have highlighted you need to think about not just, say, time-bound tolerances, for example, a system or service being down for no more than 24 hours, but other metrics. You need to be thinking about the type of customer who uses this service and the impacts it may have on them, potential losses to you or to customers. So, as I say, not just around time-bound tolerances, but other impacts and tolerances that you will accept. And I'd also, in that context, I'd highlight a statement from the FCA in 2021, where they said that consideration of the needs of vulnerable customers is central to a firm's setting of an impact tolerance, and firms should consider these groups when considering how much disruption can be tolerated. So the next thing to touch on briefly is mapping and scenario testing. So there's a requirement that firms must identify and document the people, processes, technology, facilities, and information necessary to deliver each of its important business services. And that must therefore allow the firm to identify potential vulnerabilities and remedy them as appropriate. And the key point here, I think, because we're not talking just about services that are delivered by third parties, but internally provided services as well, or services provided by another group company. The fact that a service may be provided by a third party doesn't derogate from that obligation that I just described of identifying and documenting all the different elements needed to deliver an important business service. So firms are expected to have a sufficient understanding of those elements from the third party so that they can comply with their obligations to fully map the service and the key dependencies. Just moving on in terms of vulnerabilities and remediation. So that mapping should identify vulnerabilities which might mean that you can't remain within your chosen impact tolerance. And that requires you to think about severe but plausible scenarios. So at what point does the system fail? And is that something that is sufficiently remote that you feel you don't need to or possibly can't provide for it? Another thing you need to think about is communication and self-assessment. So if an important business service is disrupted, you need to have communication plans, both in terms of internal communications and external, bearing in mind that, of course, the nature of the disruption may also impact on your normal means of communication to customers and to the wider world and indeed to regulators. And again, that's something you need to self-assess and document and record that. Another important element is horizon scanning. So favorite phrase of the FCA now is that particular requirements are not once and done. They've said that around the consumer duty, but they've also said that around operational resilience. So it needs to be something that becomes embedded within your firm, and you need to regularly refresh your management of risks and identification of the risks and new and emerging risks that may be coming down the track. And of course, you also need to think about how your business may evolve and change, and therefore how those risks might be affected. One thing that we haven't yet got, but the FCA is planning to publish a consultation paper, is to set out its expectations on how firms will report operational incidents to it to make sure that the FCA is properly notified. But of course, both PRA and the FCA have Fundamental Rule 7 or Principle 11 obligations to make general notifications, which this would probably come under in any event. So next slide, please. So just a quick summary then, as Peter's explained, the DORA is quite prescriptive in its approach, but it's specific to comprehensive ICT risk management requirements, whereas DORA is broader in its scope and covers operational risk and resilience more generally. DORA also had specific requirements in relation to critical third-party service providers, so they themselves will be potentially brought within a regulatory regime. UK doesn't have that as yet, but that is in consultation. Consultation closed in March and was provided for in the Financial Services and Markets Act 2023. So that will be coming and will be another part of the jigsaw. And as you can see on the slide in the bottom two boxes on the left, there's some quite key or quite specific requirements laid down by DORA and requirements that have to be met. The UK requirement is rather less prescriptive and is more outcomes focused. So it's about setting and firms having to identify what they consider to be important business services, their impact tolerances, and the measures they will put in place. But they need to be able to justify those to the regulators, both in advance of anything happening, but of course, in particular, if something does fail, they need to be able to explain the decisions they took and the measures they've had in place to protect themselves, their clients, and the wider UK financial system. The next slide, please. So the relevant regulatory bodies. So we've got, as you'd expect, the EU measure, you've got the European Commission in place, but you've also got the European supervisory authorities. So for this audience, it's mainly going to be, I imagine, EIOPA, the European Insurance and Occupational Pensions Authority, operating as effectively a sort of a secondary European regulator and providing guidance and rules. And we still haven't got all of the detailed measures under DORA, because those are being prepared by the ESAs and finalised in I think July is the expectation of when those will be finalised. UK requirements, on the other hand, laid down by the PRA and the FCA. As Pete mentioned, for DORA, the scope is very wide. Although there is a proportionality principle within it, it covers a very wide range of financial institutions and services. In the UK, it's a bit more narrowly focused. So it's all PRA authorised firms, well, apart from non-Solvency II insurance companies, of which there are not many, but it includes banks, Solvency II insurance companies, and also enhanced scope SMCR firms. But smaller firms, smaller intermediaries are not within the scope of the UK's operational resilience requirements. And because it includes Solvency II firms, that also includes Lloyd's and managing agents. Also, it's important to remember it includes the UK firms, but it covers all of their activities wherever they're located, because essentially it's seen as primarily it's a prudential requirement. So it doesn't matter where your activity is taking place, there's still a need to ensure effective operational resilience. One important caveat, it doesn't apply to branches that are authorised in the UK. I suppose applying that same principle in reverse. But of course, if you've got, say, a European insurer with a branch in the UK, then it will be subject to DORA. So to the extent there's overlap, then it will be having to comply with those requirements. And of course, the fact that say a European insurer has a branch in the UK but isn't subject to operational resilience, I guess could be a consideration when the PRA is looking at whether it's acceptable to have that entity continuing to operate as a branch, or whether it should be pressing for it to be set up as a subsidiary instead, and therefore directly authorised within the UK. So that could be a consideration in the future if there's concerns that entities that are operating on a branch basis don't have sufficient operational resilience to meet UK requirements. So thank you. That's all I wanted to say. We have the next slide, and I'll hand over to Alistair.
Thank you very much, Matthew. Hi, everyone. Yeah, so as we've already heard, a key limb of DORA covers the management of third-party IT services, service providers, sorry, who supply their services to in-scope financial services businesses. And all of that is covered in Chapter 5 of DORA. So in that sense, it's not only the financial entities who are in scope for DORA. You could almost say that relevant IT providers themselves are indirectly in scope on the basis that they will need to adapt their services, their contractual agreements, and their organisations in order to comply. In addition, IT providers who are deemed to be supporting so-called critical or important functions, a concept which we've already heard about, will be subject to that specific oversight framework, which Pete mentioned earlier on, which is in Chapter 5 of DORA. So if we can have the next slide, please. To begin with, I thought it was important to start by flagging what we actually mean by ICT third-party service providers, which is the full definition under DORA for these purposes. So we'll put the definition there on the slide. I'm not going to read that all out. I think everyone here can probably read that for themselves. I think the main thing, the initial observation I want to flag is the fact that it is, as everyone will be able to see, very broad. So any digital and data service provided through an IT system to one or more internal or external users on an ongoing basis, with very narrow caveats around certain types of telecom service. So yeah, incredibly broad indeed. And I can have the next slide, please. So with that definition in mind, it's time to look at the actual requirements from a contracting perspective. And we've broken this down into three key elements, three buckets, if you like, starting with the general principles which are set out in Article 28. So as we've said on the right-hand side there, this is a non-exhaustive slide. The DORA itself goes into quite a lot more detail, but want to pick out a few key examples. So looking at those general principles, firstly, wanted to say that, or flag the principle that ultimately it is the financial entity itself that remains fully responsible for compliance with obligations under DORA. Secondly, financial entities must maintain a register of information in relation to all contractual arrangements on the use of IT services provided by those third-party providers. Thirdly, and quite importantly, before entering into a contractual arrangement on the use of IT services, the financial entity needs to assess whether the arrangement covers the use of IT services supporting a critical or important function, and the contractual arrangements need to distinguish between those that do support a critical and important function and those that do not. So it's probably a good moment to look at how DORA defines a critical or important function. That's defined in Article 3, and I'm not going to read the definition out but verbatim, but it's essentially a function, the disruption of which would have a material impact on the financial performance of the financial entity, its services, or its continuing compliance with conditions or the conditions of its authorization or obligations under financial services law. So to round off the look at the general principles, another important one to be aware of, which Pete's already mentioned, is the general idea that management of third-party IT providers in this context should be implemented in light of the principle of proportionality. So in this context, in the contracting context, we're taking into account the nature, scale, and importance of IT-related dependencies and the risks arising from relevant third-party IT contracts, taking into account the criticality of the relevant service and the potential impact on the continuing availability of the financial services businesses' activities. And we'll cover this concept of proportionality again when we consider how to achieve compliance with these requirements in practice. So looking now at the row there, which touches on Article 29, this is the second bucket, if you like, when it comes to obligations on the contractual side. And here we're thinking about requirements regarding preliminary assessment of what's known as ICT concentration risk, which essentially deals with over-reliance on individual or multiple related IT providers, which might potentially endanger the ability of the financial entity to deliver critical or important functions. So yeah, those requirements here primarily relate to IT services supporting those critical or important functions. And finally, the third category, if you like, we have the specific requirements regarding the actual content of in-scope contractual arrangements. So specific provisions that need to appear in those agreements between the financial entity and in-scope third-party IT providers, and those are set out in Article 30. So yeah, looking at those specific requirements in a bit more detail, it's worth stating that Article 30 sets out requirements which apply to all in-scope agreements, and it then contains an additional set of more prescriptive requirements for contracts supporting that, again, those critical or important functions, as you might imagine. It's also worth saying that intragroup agreements are not excluded from these requirements. So DORA in its recitals actually states the intragroup provision of IT services should not be automatically considered less risky than provision of IT services by an external party. It's worth noting as well, I think we've got it on the slide there, Article 30, subsection 1, there is an overarching requirement suggesting that the relevant rights and obligations of the parties need to be set out in one single written document. So the actual wording used in DORA is, the full contract must be documented in one written document, which shall be available to the parties on paper or in a document with another downloadable, durable, and accessible format. So obvious question to ask there is, what does that actually mean in practice? Arguably, that's fairly black and white, and it seems to be saying that all rights and obligations of the two parties, including everything to comply with DORA, needs to be in a single document. On the other hand, you could say that language, which I just mentioned, leaves a bit of room for interpretation. We've not seen any specific guidance on this point as yet, but I suppose it's worth thinking about it and thinking about this requirement in the context of how technology agreements tend to look and feel nowadays. So often these days you'll have IT agreements which are modular in their form. So potentially with a core MSA or a core order form with different terms and conditions and schedules sitting elsewhere, potentially incorporated via hyperlinks. So you can start to see how complying with that one written document requirement is potentially going to be difficult in practice. Also, similarly, if we're looking to amend existing contracts to comply with DORA via side letters or variation letters, for example, again, it's going to be quite tricky to comply with that one written document requirement unless each and every time that's done, an entire kind of standalone conformed version of that contract is prepared. So yeah, watch this space, I suppose, on that one written document requirement, but we're hoping that, again, regulators are pragmatic on that point, and the principle of proportionality could potentially come into that as well. So moving on to the specific issues, which as per Article 30 need to be captured in the relevant agreements. I've deliberately not listed those out on the slide because there's a lot to digest, but wanted to basically flag that a lot of those are routine. So things that you'd expect to appear in most well-drafted IT contracts, like a requirement to have the requirement to have a clear service description. But it's really important to go through those requirements line by line, because in there you do have some quite specific and sophisticated requirements, particularly in the section dealing with agreements for services supporting critical or important functions. So things like provisions on threat-led penetration testing, which Pete's already mentioned, business continuity and contingency planning, performance monitoring, and exit planning. So the sorts of things which, yeah, are kind of more specific, wouldn't necessarily appear in all IT agreements. And if you're dealing on kind of short form SaaS terms, for example, they're not necessarily things which are going to always be in there. So yeah, the key message is the requirements are wide ranging, and it's important to think carefully about how to actually achieve compliance with that in practice. And Tim's going to talk a bit more, talk about that in a moment. And the final thing I wanted to acknowledge is that insurance businesses and financial businesses will be familiar, as Mathew's touched on in detail, with the need to update IT contract agreements to comply with various different regimes, particularly in relation to outsourcing, for example. It's important to bear in mind, though, that the scope of DORA is slightly different. So if we think about that outsourcing, the area of outsourcing in particular, DORA is not restricted to outsourcing. If we refer back to the definition earlier on, it's much more wide than that. So again, we strongly suggest that these new requirements are considered afresh, including alongside those overlapping regimes. So I'm now going to hand over to Tim, who's going to give some practical guidance on how to approach compliance with those contracting requirements. Over to you, Tim, and I think we can probably go to the next slide as well.
Thanks, Alistair. Afternoon, everyone. Nice to see you. So this particular slide captures things graphically as to what we actually need to do, and we'll run through this now. As we've seen, DORA can be a trigger for creating alignment between various other programs a particular organization has running, things like operational resilience, third-party risk management, risk remediation in tech, cloud transformation, et cetera, et cetera. And it can be a time to identify and consider what the additional requirements to be addressed are. And this slide shows how we've worked with clients on this topic in DORA. The first there is to discover and map. That's the first key step, where you should identify and locate all ICT third-party contracts, review them, and categorize them according to DORA requirements. Now, from experience here, it's important to get a solid level of engagement between legal teams, whether they're external or in-house, as well as all key business stakeholders. We've worked on matrices to do this in an advisory role to keep things on track, so there's a point of reference for those involved in the project. And then next, we recommend a gap analysis. This involves identifying the gaps in compliance with DORA contractual requirements and what you already have or what is being proposed. Next step beyond that is remediation, very much the step of reviewing and updating templates and contracting standards to meet new requirements. perhaps developing a plan for remediation of legacy ICT contracts. And that can be quite a significant exercise for large businesses, obviously. Next, if, as it says on screen, there are issues around acceptance by suppliers, then we come to outreach and negotiation. That involves carrying out contract negotiation as per a plan put in place in anticipation of that, and then reaching out to ICT third parties and negotiating DORA amendments. Clearly, the leverage you're applying there and the discussions are very much along the lines of compliance. So this is not, it's not a nice to have or an optional in that sense. And then finally, a very practical step and important to ensure business engagement is to update templates and playbooks, which many of you will have, to ensure all future contracts are compliant going forward. So you're not baking in other aspects or non-DORA compliant aspects going forwards. I think we've lost the slides again, so maybe we can get those back on screen. But while we do, as commercial lawyers, we work closely with clients on these things, and we're mindful, obviously, that balancing DORA compliance with operational demands and, of course, costs of various types is a strategic challenge. Yeah, next slide, please. And that challenge does require a nuanced approach. So on screen, back one slide, please. On screen there, you can see a few boxes, and these illustrate and capture the key considerations. Firstly, their cost benefits, having a proper analysis to understand the long-term savings that come from avoiding major ICT disruptions versus the initial and ongoing costs of compliance. Versus may not necessarily be the right word. It's more about parallel consideration there, I'd suggest. And then scalable solutions. So investing in scalable solutions that grow and evolve with the organization and adapt to changing regulatory requirements. We're always keen to anticipate evolution as well as advising on things that are already happening. So ultimately is done with a void to need frequent, costly upgrades. Efficiency, clearly very important. That can be achieved through automation and leveraging that automation to streamline the compliance process, reduce errors, and lower op costs over time. And then in the strategic box, integrating DORA compliance into broader business strategy to ensure that resilience becomes a real competitive advantage for you rather than a cost center, the positive way of looking at that. And then in the other box there are some things that I just wanted to flag, which can be material in this area. Very much achieving a balance between DORA compliance and operational steps and costs. It isn't a one-time effort. It's an ongoing process. So it does require strategic investment in tech and processes that not only meet current regulatory requirements, but also position a particular organization to respond to future challenges. And then if you embed resilience into the DNA of the organization, I'd say this more widely as an IT lawyer, the financial entities can really ensure they're not only compliant with DORA, but also capable of withstanding and quickly recovering from ICT-related disruptions. Cyber, an obvious one there that falls into that category. So the balance, just as a wrapper here, is not just about meeting regulatory expectations, very much about safeguarding reputation, customer trust, and building out robust contractual structures. The next slide is a graphical illustration of what we're talking about. One size does not fit all. Clearly, you can put in place structures and approaches, and we can learn from what we're seeing in the markets and advising clients to support in this space. But there is that dial of risk. And inevitably, you need to find the right place on that dial for your particular organization. So thank you very much. I'm going to hand back over to Pete.
Thanks, Tim. Next slide, please. And the next one. So I think that's a nice segue into kind of the steps that organizations should be taking at the moment. And I suspect, obviously, we've got a very large number of participants on the call, obviously a range of organizations. So I suspect that different organizations will be at different stages of their journey And that's certainly something that's reflective in the conversations that we're having with clients at the moment. I suppose just a few thoughts, and apologies in advance for teaching people to suck eggs, but perhaps it's just helpful to kind of see what, set out what we're seeing, what we think would work well here. So I think the first thing is that DORA is obviously a lengthy, complex law. And obviously it doesn't sit in a silo for obviously organisations that operate across the UK and the EU. There's the two regimes that we've covered. So it's important to have a compliance programme stood up to ensure that you're in the best possible position for getting your business in shape for the DORA deadline in January next year. I think a big part of sort of getting in shape is going to be looking at what you already have in place from an ICT risk management perspective and carrying out a gap analysis. So effectively you're making good and leveraging on the framework that you already have in place. And actually our experience shows that the organisations are likely to have a number of the requirements of DORA already in place, either as a result of existing regulatory requirements or just good information security practice. And obviously Alistair's picked up on the point that actually, in terms of the contracting requirements, much of what's in there is either going to be requirements that were set by existing rules or just as a matter of sort of prudent drafting. That said, the requirements are far-reaching, and so it's possible that not everything is covered. And as I say, that's why it's important to do this gap analysis. However, the reach of DORA is extensive, and as I say, the requirements are extensive as well. And so organisations are likely to need to think carefully about prioritising their approach to ensuring compliance with DORA, and prioritising and risk assessing those areas where they need to make changes. I think a sort of key element of this is going to be focusing on ICT services that support critical and important functions. The reason being that those are obviously the more critical and important functions for the business, and therefore like to be associated with a high level of risk, but also the more onerous requirements of DORA attached to the SIFs. So things like breach notification obligations, more onerous contracting requirements, and so on. So an important exercise is going to be identifying and mapping your SIFs, and obviously there's a potential overlap with the UK regime in terms of important business services. And then, of course, it's going to be important to create an implementation plan and execute on that, and keep regular tabs on it to make sure that you're working towards compliance by that 17th of January 2025 deadline. I think it's probably worth underlining that some of these requirements are likely to have a longer lead time. So things like contract remediation, to the extent it's required, experience shows that could be quite there can be quite a long lead time there in terms of achieving remediation of contracts, both in terms of the time it takes to identify the contracts, work out which ones need to be uplifted, and then actually going through the process of remediating them and negotiating with third parties. I think just another point to flag here, I touched on it earlier, is that while DORA obviously is not limited to personal data processing, it's obviously much broader in scope. There are various elements of DORA that are likely to dovetail with your GDPR compliance frameworks. So things like breach notification, things like the requirements around contracting with third parties, and the approach that you take there, and also certain accountability tools. So things like your Article 30 records. There are various elements of DORA that require mapping and inventories to be taken, both of contracts and systems and information ICT assets. So I think the important point there is to make sure that you're not reinventing the wheel, that you're dovetailing with existing frameworks that you have in place, and leveraging the sort of the items that you've already got. Could I have the next slide, please? And the next one. We just wanted to finish with a sort of a brief eye to the future, what's coming down the line. I think with a particular slant to DORA, it's worth sort of flagging, I suppose, a couple of key dates. The first being more imminent. So as has been mentioned, DORA is obviously the law, but actually various elements of DORA are supplemented by regulatory technical standards and implementing technical standards that are being produced by European supervisory authorities. and various of those have been published so far. The next batch though is due in July this year. So it's important to have regard to those ITSs and RTSs because they put the meat on the bones of the DORA framework in various elements. So for instance, on breach notification, DORA doesn't actually set out the time periods for when breaches must be notified, but those will be set out in the RTSs that accompany that particular article. And the other point, just to hammer it home, just so it's in front and centre for everyone, is that the deadline for getting compliant with DORA is the 17th of January next year. So we've still got time. It's still 7.5 months, but obviously it's now important to to make sure it's really a focus and a priority to make sure that deadline's hit. Thank you. Next slide, please. So we've got a few questions in the chat, which we can spend some time going through. So I think the first question around proportionality. So the question is the definition of proportionality effectively an individual making an assessment which is well thought out and properly documented and hope the regulator agrees? I mean, I think in terms of Article 4 of DORA, it doesn't provide that level of detail, but certainly I think that sounds like a prudent course of action to take. The article sets out what you need to consider when you're assessing proportionality, and I think from a sort of accountability and a good governance perspective, keeping a record of the decisions you've made based on that proportionality assessment is sensible.
I was just going to say, Peter, we've had quite a few attendees ask the question about the applicability of DORA. And I think so, does DORA apply to EU entities operating abroad? And then conversely, if you're a UK entity, does DORA apply to you? So we've had kind of like both of those questions asked, and different attendees have asked that very same question. So it might be worthwhile giving a brief overview of the applicability of DORA.
Yeah, I think sorry, I've been watching the answers, and I'm happy for others to chip in as well. I think sort of the broad point is that the scope of DORA is broad, and it will apply to activities that are performed outside the EU. So it doesn't necessarily apply only to ICT risks and ICT infrastructure that exists in the EU. It has a broader application. I think sort of specific questions around the scope are going to be worth looking at on a case-by-case basis, not sort of not in general terms. I mean, the other, I think, sort of more general point in terms of extraterritoriality is in relation to the ICT third-party regime, critical ICT third parties. So the DORA is very clear that can extend to non-EU critical ICT third-party service providers. And actually, if such a provider is designated as such, then there is a requirement for that entity to incorporate a subsidiary in the EU. So there's a touch point for the regulators there. So I think sort of the general point is there, the DORA is intended to have a sort of broad application.
Thank you. And I think going to one of the earlier questions in respect of a UK-based financial entity, but actually may provide services in the EU, then they may also be caught by DORA.
Yeah, I think potentially. I think that's, yeah. But as I say, I think it's something that's worth teasing out on a
case-by-case basis.
Yeah, exactly.
Thank you.
I think this is, sorry, I'm just reading the questions. There's another one I'm just quickly skimming through on proportionality, which again, I think there's there is a sorry, bear with me, a copy of the regulation, because I think one of the elements of proportionality is around size. So just bear with me. Oops. Yeah, scale and complexity. Yeah. So I think the question was, are there any proportionality considerations where a multinational group has a very small EU entity utilizing group services? I mean, I think that one element of the proportionality principle is to take into account, or when assessing proportionality, to take into account size, risk profile, nature, scale, complexity of services. So, a small EU entity, potentially that's going to have an implication in terms of that proportionality assessment. And I think that probably picks up on that second question on examples regarding proportionality. So the key principle to look, also the key article to look at is Article 4, which sets out the sort of things that need to be considered when you're assessing proportionality. So it says taking into account size, risk profile, nature, scale, complexity of services, activities and operations.